A Sean Combs accuser can no longer remain anonymous. The government is fighting back against allegations of leaking information, and they also say the embattled rapper doesn't have a right to know more about the case just yet. We're going to break down some new legal developments in the ongoing saga of Diddy. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, so we got some legal filings in the Sean Diddy Combs case that I want to go through. And of course, right now, Combs is locked up, pending trial on federal charges of racketeering conspiracy, sex trafficking, transportation to engage in prostitution. The allegations being that starting in 2008, Combs and others participated in a criminal enterprise that used violence and obstruction to accomplish its mission, its goals. This included engaging in kidnapping, arson, bribery, that they used Combs' power and prestige to force women to engage in prolonged sex acts with male sex workers. These are those infamous freak-offs that we've talked about. And Combs allegedly directed these sessions, recorded them. But moreover, prosecutors allege that Combs engaged in a campaign of physically assaulting, sexually abusing, and threatening women. But now let's talk about the latest. We have a couple of filings we want to talk about. And first up, the government filed something called opposition to the defendant's motions for a hearing, bill of particulars, and gag order. A lot of legalese. I'm going to break it down. So they are addressing a few things here. First, they're asking the court to deny Combs' request for the court to hold an evidentiary hearing regarding alleged leaks made by the government. Now, we've discussed this before, but Combs' team has asserted that Homeland Security agents, you know, the ones that raided his properties back in March, that they were the ones who leaked that infamous 2016 videotape of him purportedly beating Cassandra Ventura, his ex-girlfriend, in a hotel hallway. Remember, this was published by CNN. The government says, wait, there is no leak of any grand jury material here, which would be illegal under the law. All of this, really what the defense is doing, Judge, all of this is just an effort to suppress what would be a key piece of evidence in Combs' trial. Because after all, if the government really did improperly leak this video, it could arguably be prevented from coming into trial. But the government says, quote, but as the defendant is fully aware, the video was not in the government's possession at the time of CNN's publication, and the government has never at any point obtained the video through grand jury process. They also say the defendant baselessly accuses DHS agents who have no authority to issue grand jury process of secretly obtaining the intercontinental video unbeknownst to the prosecutors conducting the investigation and then leaking it to CNN. No evidentiary hearing is necessary to reject these assertions as incredible. Prosecutors also say the government ultimately obtained the intercontinental video at the same time as the general public on May 17, 2024, when CNN publicly released the footage. The morning that CNN released the intercontinental video, counsel for the defendant contacted the prosecutors assigned to the case to alert them that CNN had the video and expressed a concern that someone provided this footage to CNN. But here's the thing. Prosecutors said, you know what? We don't have the original copy of this video. We never got it. We tried to look for it. We tried to find it. We knew about it before it was published, meaning they knew it existed somewhere, but all they knew was that it had disappeared from the hotel server. And of course, there were allegations that Combs was instrumental in making this video disappear, even allegedly trying to bribe a security guard. So the government is like, this was never grand jury material. They even told Combs' lawyers in an email that they didn't have the video before CNN published it. In fact, in an email from prosecutor Emily Johnson to Sean Combs' defense team, which is attached to this filing, it says, to be clear, to our understanding, DHS did not have possession of the videotape prior to CNN's publication of it. The prosecutors also write that it strains credulity to suggest that law enforcement agents independently obtain the intercontinental video with a grand jury subpoena they have no authority to issue. The defendant refuses to acknowledge that multiple individuals other than government agents, including some of his own employees, may have had access to the intercontinental video. So that's something we've always wondered. I mean, how did CNN get it? Who leaked it to them? Where did it come from exactly? Was it somebody from Sean Combs' camp? Maybe. And they also explain how, yes, look, of course, there is a need for secrecy of the grand jury process. That's clear, right? Because if you don't have secrecy with the grand jury process, then Witnesses may not testify, or it may affect their testimony if it's all out in the open, or the target of an investigation may flee if they know a grand jury is looking into them. But despite all that, the government says the federal rules regarding what can and can't be disclosed about the grand jury, it doesn't apply to information that's obtained independently outside of the grand jury process. In other words, this tape wasn't grand jury material. It wasn't non-public information that the government had in its possession. So that's all issue one as to why the prosecutors say Sean Combs is not entitled to an evidentiary hearing looking into alleged misconduct by the government. By the way, what do I talk about like all the time on Sidebar? I talk about the law, right? I talk about the law on Law and Crime Sidebar. I talk about legal rulings, legal decisions. Well, I have a landmark one for you right now that has just changed things in a massive way. Why? Because you can now legally trade on who will win the 2024 election. Yes, this is legal. And that is because our sponsor of Sidebar, Kalshi, went to court and won legal approval for election trading for the first time in over 100 years. So not only can you essentially bet on the 2024 presidential election winner, but with Kalshi, you can bet on who will control the House and Senate, who's going to win the swing states. I mean, what's happening next week? It's pretty timely. It's not just politics, by the way. You can bet on other future events too, like will Taylor Swift win top artist on Spotify this year? What's going to be the Rotten Tomatoes score for upcoming movies like Gladiator 2? I actually think it's going to crush it. I think it's going to be above 85%. But there's so much more you're going to be like, wow, I can trade on that? Yes, this is the only place to trade on events like this in all 50 states. And right now you can sign up using our link kalshi.com/sidebar, or you can scan the QR code on screen. And if you're one of the first 500 traders who deposit $100, Kalshi will give you a free $20 credit. That's kalshi.com/sidebar. This is issue two. They say, quote, the defendant also complains about purported law enforcement sources leaking other alleged grand jury material to the media in several news articles cited in his papers and set forth in the attached table. This is where Combs' attorneys have made the argument, the allegation, that the government is improperly saying things to the media. For example, Combs' lawyers had cited a Deadline.com article that was reported on October 15th, 2024, and in that article, that a, quote, law enforcement source with knowledge of the case stated how all the defense was doing was shaming the alleged victims. It's part of the defense offense course of action, and they'll try anything. So prosecutors responded here, and they say the defendant is grasping at straws. Because the defendant cannot show that the information in the cited articles is grand jury material, and because he cannot show that government agents with access to grand jury material leaked the information, he can't make the prima facie showing required for the relief he seeks. And the reason for that is because prosecutors say that these comments to the media in these articles, it's all about the searches from Combs' property and what was recovered by law enforcement. And by law, that's not secret. That's not protected grand jury material that can't be disclosed. Information that's obtained by search warrants is not covered by the grand jury secrecy rule. And the same thing applies to information that's collected via wiretaps or witness interviews. The government also says, quote, moreover, none of the cited articles indicate on their face that any leaked information came from government attorneys or members of the prosecution team. Even the articles that attribute information to law enforcement do so vaguely, citing law enforcement sources or sources familiar with the investigation. To meet the burden, a far more explicit connection between the alleged leak and the law enforcement officers conducting the investigation is required. So that's all the reasons why they're saying, court, don't grant Sean Combs an evidentiary hearing. There's nothing to be decided here. Okay, this is another point that the prosecutors want to address. They are saying that Sean Combs is also not entitled to what is called a bill of particulars in this case. So a bill of particulars is when a defendant says to the government, I need some more. I need some more clarity on my charges. You need to itemize it out for me. I need more details on each charge so I can properly understand the case, so I can properly defend myself. And it's a way for a defendant to avoid being surprised at trial. Prosecutors here are like, no, not so fast. You don't need this. It's unnecessary. And you know what? It's improper. They write, quote, as an initial matter, The defendant has been more than sufficiently apprised of the charges he faces, including through a 14-page speaking indictment, the government's submissions, and statements on the record in connection with the defendant's bail hearings and significant productions of discovery. And at the appropriate times, in accordance with the well-established practices in this district, the defendant will receive even more disclosures about the conduct with which he is charged, including through additional discovery, an enterprise letter, a witness and exhibit list. Accordingly, the defendant cannot credibly claim that he will suffer unfair surprise at trial. Rather, it is plain that the defendant's request for a bill of particulars containing victims' names is merely a vehicle to attempt to prematurely restrict the government's proof at trial and use these criminal proceedings to defend himself in the press against complaints in separate civil litigation. This improper request should be denied in its entirety. So that's a big statement to make. And what they're basically saying is, Sean Combs, look, we have been clear about your charges, but you know what? You will get more evidence in time about your crimes. And you can't just request this to help you defend yourself in the myriad of civil lawsuits that you currently face, suggesting that there's an overlap between the criminal case and the civil actions. And the prosecution's like, look, also with a bill of particulars, you got to be careful because you can't use it to limit the prosecution's case. Oh, we're only going to limit the government's case to this specific proof. If that's what happens, that would restrict the prosecutor's ability to present its case at trial to what's only in this bill of particulars. And there's a lot of evidence here. This is a constantly evolving investigation. They say this is not right. And also they make the point about identifying victims because obviously Sean Combs wants to know who his accusers are after all. And to be clear, no victims or even witnesses are identified by name in the indictment or any of the government's papers. But the government has a response to that. Hey, we need the bill of particulars to ID the victims. They write, the defendants claim that there is no way for Mr. Combs to determine who the other unidentified alleged victims are rings hollow. The indictment, along with other disclosures, including discovery, adequately advises the defendant of the criminal acts of which he is accused and accordingly of potential victims. To the contrary, the victims are individuals whom the defendant is alleged to have trafficked, violently assaulted, and transported across state lines for commercial sex, among other criminal acts in which the defendant directly participated. So in other words, you should know who these people are. Now, there's one other thing I have to add here. The government, in this filing, they reveal not only what evidence they have in their possession, but what they've turned over to the defense. And this is significant. They write, the government has made 3 significant productions of discovery material, which include the following categories of materials: all search warrants and supporting affidavits, hotel, financial, and communication records produced pursuant to grand jury subpoenas, and electronically stored information from over 60 of the defendant's own devices and iCloud accounts, including, among other things, text messages, audio and video recordings, photographs, and documents which the defendant had requested be prioritized. These materials contain additional details about the allegations against the defendant, including, for example, specific allegations relating to multiple victims in search warrant affidavits and communications with victims and witnesses from the defendant's devices. So that makes me wonder if that ties back to the allegation that he had been improperly contacting witnesses, and one of the reasons why he's been denied bail. So again, that could be really, really key evidence that has been turned over to the defense. But in other words, big picture here, they're saying, Combs, you should have an idea of what's happening here. You know who these people are. Now, continuing on with the government, they say, look, defense, don't worry. We aren't going to surprise you. We're not going to surprise you at trial. We will give you 15 days notice prior to trial of any witness or any evidence that we're going to introduce. And I've said this before, when it comes to federal cases, it's not as transparent at state cases. And look, providing information 15 days before trial, we might not know who the victims or the witnesses are until much later in this investigation, much later in this case. So with a May 2025 trial date, we might not know things till closer to. But prosecutors say there's another danger here too, that we don't want to readily disclose the names of these victims because Combs, he has been accused of a wide-ranging set of violent acts and threats and obstruction as part of this racketeering case. And there are serious allegations that Combs engaged in witness tampering, implying that there could be a risk to the victim's safety and ability of witnesses to testify if their names are revealed to Sean Combs. By the way, I want you to keep that in mind because we're going to talk about something else in a little bit. Finally, there's one more issue that the government addresses in this filing that we need to talk about, and that concerns Combs' attempt to basically, essentially, stop accusers from speaking to the media about their claims. And you know, there have been many public comments made about the lawsuits and so forth, but the government says what Combs is doing is underhanded. Quote, by providing potential witnesses in the criminal case and their counsel for making extrajudicial statements, the defendant is essentially asking for either a blanket order that would apply indiscriminately to any individuals with claims against Combs and their lawyers, or for a more limited order that would require the government to identify its witnesses 6 months before trial. Not only would such relief be unprecedented, but the defendant should not be permitted to use a local criminal rule as a sword to gag civil claimants whether or not their statements were connected to this criminal proceeding or to evade established case law in this circuit. So in other words, this is an underhanded attempt to try to identify these people once again, and they are saying that Combs' gag motion on the victims, that should be denied. By the way, one more thing I have to call out about this filing, because at one point in this filing, the prosecutors reveal when they started looking into Sean Combs. Quote, in or around November 2023, and as described in more detail below, federal prosecutors from the United States Attorney's Office for the Southern District of New York, working with case agents from the Human Trafficking Squad of the New York Field Office of Homeland Security Investigations, began investigating Combs and others for violations of federal criminal law. That is so significant because we always believed it was the lawsuits that were filed against Sean Combs, specifically the one from Cassandra Ventura that was filed in November of 2023, that started this criminal investigation. So a statement like that sure looks like it was the lawsuits that started the criminal investigation. Okay, now, another thing I need to mention was that the day after this brief was filed, the judge overseeing this criminal case, Judge Arun Subramanian, said that the court had received a letter from prosecutors too, and it was a letter supporting what they just laid out, everything that I just mentioned. But prosecutors had asked the court to seal the letter so no one can see it. So perhaps there was some sensitive information in there? We don't know, but it's notable that prosecutors had asked for that. But that is not all we have to talk about, because we have to talk about Sean Combs having a right to face his accusers. Moreover, more specifically, I should say, to the civil context, because Combs got a win this week in one of the cases filed by Texas attorney Tony Busby. Remember him? He's the attorney who has vowed to file over 100 lawsuits against Sean Combs from all of these accusers. He's already filed multiple lawsuits in the last few weeks. And one of those lawsuits is from an unidentified woman who filed a lawsuit against Combs in New York federal court, and she alleged that Combs raped her and threatened her life in 2004 when she was just 19 years old. The issue, though, is that she filed this lawsuit under a pseudonym, Jane Doe, which, by the way, a lot of Combs' accusers have done recently. But Judge Mary K. Viscosil issued an order saying, nope, she can't do this. She can't continue to proceed with this case under a pseudonym. I'm going to break it down why. So under the federal rules, a person filing a lawsuit has to actually name all the parties. And look, the public has a right to know who is using their courts for initiating legal actions. This is actually backed by the First Amendment. And really, the only time a plaintiff can refrain from being named is if there is a substantial privacy concern that outweighs everything else. And here the court says the plaintiff fails in showing that. First, the court says that while sexual assault allegations are highly sensitive and personal, that in and of itself is not enough. As to the argument, well, we can't reveal Jane Doe's identity because that will risk her safety, the court was unpersuaded because they say she didn't provide any support of how her safety would be in jeopardy other than her claiming that 20 years ago, Sean Combs threatened her life if she ran away. The thing is, he hasn't contacted her in 20 years. And the court says Jane Doe claiming she will suffer mental harm if her identity is revealed. The problem with that is public humiliation is not enough. The court says you can't just make a blanket argument that revealing your identity would further victimize you, because then every sexual assault accuser would have to proceed anonymously, which is not what the law allows. And by the way, other people have sued Sean Combs and have identified themselves, and their allegations are heinous and sensitive and embarrassing and subject themselves to scrutiny. So Jane Doe, you can be really no different unless you show more. And the court's saying, Jane Doe, if you want to proceed anonymously, you need to show evidence of the harm that you would suffer, like a statement from a mental health professional, or maybe a sworn affidavit from Jane Doe. And the court makes a good point too here, because they say, you brought this lawsuit. This was your decision. You know that you are putting your credibility at risk. This was your choice. Sean Combs has a right to investigate his accuser, to challenge her allegations, to challenge her credibility. Sean Combs needs to know who this is. And they explain later on in the brief, you're also talking about alleged misconduct from 20 years ago, which is difficult to defend even if you knew who the plaintiff was. But to not know who she is, you're making the defense's case a lot more difficult when it shouldn't be. And there are other reasons why the court says that she can no longer use a pseudonym. For example, they say this is just the most extreme option. You can use redactions to protect highly sensitive material. You don't need to just refer to Jane Doe for the rest of this case. And the court concluded as follows. Plaintiff has an interest in keeping her identity private given the sensitive nature of her allegations, the potential for public scrutiny of her personal life, and her decision thus far not to speak publicly. But plaintiff, who is an adult, has now decided to file a lawsuit in which she accuses a famous person of engaging in heinous conduct approximately 20 years ago, and further accuses a number of businesses of complicity in that alleged conduct. Defendants have a right to defend themselves, including by investigating plaintiff, and the people have a right to know who is using their courts. Plaintiff has not carried her burden to show that she is entitled to the exceptional remedy of anonymity. For the reasons set forth above, plaintiff's motion to proceed under a pseudonym is denied. Plaintiff shall file a complaint in her own name by November 13th, 2024, or this case will be dismissed. Well, I gotta wonder if Jane Doe is actually going to move forward with this case now that she has to be identified. And given this legal rationale, will this apply to all of the other Jane and John Does that have filed similar lawsuits in the same jurisdiction? This is a semi-win for Sean Combs. Let's see what happens next. That's all we have for you here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.